What's up, guys? Welcome to the Legal Doc Guy podcast, where we are currently going over multiple choice questions, MBEs for the California State Bar. Today, I got a doozy for you. We are looking into a real property question, which I have here, and we're just gonna kind of jump into it. All right, we're just gonna read off the question, and we're gonna tackle it just one step at a time. So here we go. So here's the question. So whenever you're, this is how they teach it in law school. Well, actually, they don't even teach it at all in law school. When I was in law school, we didn't even talk hardly at all about multiple choice questions, to be honest with you. But when I took bar review courses, a lot of instructors will agree that you should first start off with the call of the question in a multiple choice question. Briefly, if you have time, depending, just kind of practice. You might glance over the answers, the possible answers, and then start by reading the first paragraph. I've done this many different ways. I've done this in ways where I started off by reading the call of the question. In this case, the call of the question is saying, if the man prevails in an appropriate action to recover title to the property, what is the most likely reason? Now, the cool thing about starting off that way is that the call of the question will let you know what world you're in. Because, you got about, a minute and 40 seconds, maybe. I forget the exact amount of time to answer. If you were to put an equal amount of time between each question, which is 200 on the California State Bar, 100, there's 100 in the first session, another 100 in the second session. If you were to divide that up, that'd be about a minute and 42 seconds or something like that. I will make sure I answer that question on another video because I don't want to take the time to actually do the math on that right now. However, if you read the call of the question, let's see, so I change this up. So if you read the call of the question first, it'll let you know exactly where you are. It's a real property question because right away it tells you the man prevails in appropriate action to recover title to the property. That word right there, recover title to property, is going to let you know, okay, this is a real property question. It's not going to be a criminal law question. It's not going to be an evidence question. It's asking you about title, and it's asking you about real property. So the question's asking, let me get out of here. A man owned property that he used as his residence. The man received a loan secured by a mortgage on the property from the bank. Later, the man defaulted on the loan. The bank then brought an appropriate action to foreclose the mortgage, was the sole bidder at the judicial sale, and received title to the property as a result of the foreclosure sale. Shortly after the foreclosure sale, the man received a substantial inheritance. He approached the bank to purchase the property, but the bank decided to build a branch office on the property and declined to sell it back to him. It declined to sell. Call the question one more time, but the man prevails. So the fact pattern is telling you that the man prevails. If the man prevails, but it's telling you he prevails. In the appropriate action, recover title to the property. What is the most likely reason? Okay, so right off the bat, we know the man prevails. There's a lot going on here. And in order to answer this question, you have to understand the processes of when a person defaults on a loan, what the procedures would be as far as that foreclosure. So keep in mind here. So here's the thing. If you didn't know, there's the foreclosure on the mortgage, and then there's a foreclosure sale. So looking at these answers here, we should be able to eliminate 50% of the answers in this of these four choices. A says he had used the property as his residence. Right away in the fact pattern, a man owned property that he used as his residence. Is that relevant? Not necessarily, because the rules could apply even if it's not your residence. It could possibly be a building. I'm not 100% sure on that. If you know if what I just said is correct, put it down in the comment section. Help us out. So I'm going to say right off the bat, choice A is not relevant. He used the property as his residence. Who cares? B, he timely exercised an equitable right of redemption. Well, we know that redemption is the issue here. And let's go. If you look at D, the jurisdiction provides for statutory right of redemption. You'll see here that there's two different types of redemption here. And choice C, the court applied the doctrine of exoneration. So you would have to know what exoneration means. And the doctrine of the court applied the doctrine of, so the doctrine of exoneration has to do with when the party dies. So I'm going to say we know that the man is alive. So it has nothing to do with the doctrine of exoneration. That's not why he won. This is a Word document, so I got to make sure I don't delete it. But what we know is, if you know what the doctrine of exoneration is, you're going to know right off the bat. Well, the man's alive. There's nothing in here that says he died. So I could eliminate choice C. I'm going to be able to eliminate choice A and choice C. So I've now narrowed this down to two possible answers, either choice B or choice D. So tell me in the comment section, pause the video right now and think about it, read the question, and get out a piece of paper and write down whether you think it's B or it's D, and then come back to the video. Okay, good. Welcome back. You came back. Fantastic. I'm assuming you paused the video to really think about this. So what you need to know in order to answer this question is, when can someone exercise an equitable right of redemption? And the answer to that question is, you would have to exercise equitable right of redemption between when the foreclosure commences, so the start of the foreclosure, to when the foreclosure sale actually occurs. So you have that time frame from when the bank forecloses and from the time the foreclosure sale occurs. If the foreclosure sale comes and goes, meaning if you see here in the fact pattern, it tells you appropriate action to foreclose the mortgage. So it tells you the bank then brought an appropriate action to foreclose the mortgage. That part right there, that is when when it began, his right to equitable right of redemption. That's when his time started, that he could exercise that right, that equitable right of redemption occurs once the bank started the foreclosure process. He could then exercise that right. Obviously, when they started the foreclosure process, he didn't have any money, because it says shortly after the foreclosure sale, he received a substantial inheritance. Okay, you see that right here. Shortly after the sale, the man received a substantial inheritance. And then right after here, it tells you the bank was the appropriate action for foreclosure. The bank was also the sole bidder at the judicial sale, and they received title to the property as a result of the foreclosure sale. So that tells us, those facts right there tell us that he did not receive that money, the inheritance money, to pay off his debt until after the bank had already sold the property. And they sold it to themselves. See, the bank brought the appropriate action for foreclosure. They were the sole bidder. They were the only people who bid on the property, so they sold it to themselves, and they received title to the property as a result of the sale. So if you know that rule, you know that he did not timely exercise an equitable right of redemption. It's not because the time had come and gone after the sale, after the foreclosure sale. So then you have to look at choice D. The jurisdiction provides for a statutory right of redemption. Now, what we need to know is that not every jurisdiction has statutes that will provide for that person to have the right of redemption, to purchase back that property. But if it does, it generally means that there's a short amount of time after the sale, after it's already been sold, that they could redeem or redemption. They could exercise the right of redemption statutorily, meaning that there's a rule in the books, there's a law a state law that allows for, in that one jurisdiction, whatever jurisdiction they're in that state, that will provide for redemption. So, say for example, they sold it, and the jurisdiction provides for the statutory right of redemption 2 weeks after the sale, and as long as he exercised that provision within that time frame after the sale of the property, he will be able to purchase back that property, because it says shortly after the sale. Now, if he prevails, that means that that the jurisdiction, in that jurisdiction, there's a statutory right of redemption, because he already screwed up. Or he didn't screw up, but he didn't know when he's going to get that inheritance. He can't control when people die and leave you money. But he did not have the money before that foreclosure sale, so therefore an equitable right of redemption was not available to him. But instead, the jurisdiction allowed for the statutory right of redemption, meaning that that particular jurisdiction. Now, we just have to remember that not every jurisdiction allows for this. But if it does, then you can absolutely take advantage of that. There was one more thing I wanted to address, but I forgot. But if you guys have any questions about this particular question, you can absolutely message in the comment, and I will actually provide an answer for you. This is actually a very good question, and this is like if you know the rule, it's an easy one. So, anyhow, that's the question. I hope you guys got a kick out of this one. It's a very good question. It's one that could come up on the bar exam, or something similar to it could come up on the bar exam. And just remember, they try to throw you off with stuff like, because it's used as his residence. It's like, who cares? If you know if you know where you are in the foreclosure stage, if you know what stage you are in the foreclosure, you'll know whether or not an equitable right of redemption is available. You just got to remember that equitable right is only available between when the foreclosure commences and when it's and between the foreclosure sale. So if the fact pattern tells you that the bank has started the foreclosure process, but has not yet sold the property, and the person prevails, that it's probably because they exercised an equitable right of redemption. And just remember, not every jurisdiction provides for this statutory right of redemption. Many jurisdictions don't have this. Once the property is sold, it's sold. So if he wins, and if the equitable right has already passed, then it could only be because that jurisdiction has a statutory provision to redeem redemption of that property. Property questions are a very tough one. They generally have very long fact patterns that can really take up a lot of time. So it's really important to hit these questions a lot, so that you can recognize what's going on right away, because you're only going to have you have less than 2 minutes per question. And if you're spending 2 minutes just reading the fact pattern and trying to understand it, that's going to eat into your time, and you're going to end up not being able to answer all the questions, or you're going to end up guessing on the last 10 or 15 questions once the third hour starts approaching. Because per 100 questions, you only get 3 hours to answer. So you want to make sure you're prepared for that. All right, guys, if you have any questions about this particular question, please leave a comment in the comment section. Remember, this is the Legal Doc Guy podcast. You can find me, you can email me at legaldocguy@yahoo.com if you have any questions that you would prefer to have through email, or if you're somebody who knows someone who's going through a legal situation that they can't hire a lawyer. I do legal document preparation, where I assist people with divorces, child custody, small claims. I have done some landlord-tenant stuff. I can create wills and trusts, things like that. If you guys, for a reasonable price for people who don't want to pay the exorbitant amount of money, I don't know if that's the right word, but pay a lot of money for somebody to do something for them that they could almost do for themselves, but they just need some guidance. I do that for a reasonable fee, where, generally 20% or something like that of what a lawyer would charge, an actual lawyer, which I am not an actual lawyer. I'm a law school graduate, and I've been doing law in motion and paralegal and law clerk type work for the last 10 years. I am also taking the California bar in July of 2026. So pray for me. Just hope I pass this time. But anyway, all right, guys. Catch you guys on the next one.